Now, two very important
So,
sections. to be
ಇದರಲ್ಲಿ
noted.
one of the instance is what the petitioner is alleged of performing.
Obliged. Kindly permit me to show two more provisions, namely section 29. Like the normal
Yes, sir.
foundation for criminal jurisprudence,
Yes.
that a man is presumed to be innocent. Here is a provision under section 29, where a person is prosecuted for committing or abetting or attempting to commit any offense
No, this is
under sections 3,
reverse
5,
burden here.
yes, 7. The special court shall presume such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is. So when is the contrary proved? It can be proved only at the trial. This is a rebuttable presumption. This is not a conclusive
Correct.
rebuttable presumption. Now section 30 also may kindly be seen. So this is with reference to the offense. He is presumed to be guilty when this thing is prosecuted. Mere prosecution is evident. Section 30 may kindly be seen. Presumption of culpable mental state, because here he is required to touch with the sexual intent, whether it was an affectionate hug, whether it was an affectionate this thing, or it
So
was
if
with
the
a sex.
allegations are seen, it cannot be a good touch at all. Yes. Allegation.
30.
Prima facie.
The reason why I am insisting on these two provisions is the presumption of a culpable mental state in any prosecution for any offense under this act, which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. So it is at the trial that he can establish, can step into the witness box, because there is nobody else who has seen it, and there is nobody else who is a witness to it.
There is no eyewitness.
Except the victim, who has sworn to the fact that she was molested. Okay. Now, having said this, so there is a presumption, statutory presumption in favor of the guilt of the accused. There is a statutory favor in favor of presumption that it was done with sexual intent. These two presumptions are there, and the act, kindly come to the preamble of the act for a minute. Only one sentence I'll.
Yes.
Last but one sentence before the commencement of the provision, be it enacted by Parliament so and so. Before that, one sentence may kindly be seen. And whereas sexual exploitation and sexual abuse of children are heinous crimes and need to be effected. So this has Parliament itself has declared that it is a heinous.
There can
that
be no
it is
qualm
a-
about that.
It is a heinous crime.
Yes.
So it is in this backdrop, my very respectful submission is, in the light of the presumption that a 482 petition does not lie in respect of cases under POCSO, for the reason that there is a statutory presumption and he is presumed to be guilty. Once he is prosecuted,
Reverse burden.
he is presumed to be guilty. Even the sexual intent is presumed under section 30. So this being said, that is the first objection I have for the maintainability of it. Now, I would also request the court to kindly find out from the evidence I have already placed before the court that the prosecution has made out a strong foolproof case that there exists a prima facie case. Unless he rebuts these presumptions, he will not be. In order to demonstrate the prima facie nature, kindly permit me to show the statements made by the victim.
Yes.
ಅವರೇನೋ ಕಂಪೈಲೇಷನ್ ಹಾಕಿದಾರಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದೆಯಾ?
Lokaयुक्त has, I mean, SIT has filed the charge sheet put here.
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇದೆ.
Charge sheet.
Yes, yes. Charge sheet is here. ಬೇರೆ ಇದೆಯಾ?
ಹೌದು. ನಾವು neatly bound copies are given so that the pages tally.
Charge sheet is here anyway, but
ಕೊಡಿ ಅದು. ಚಾರ್ಟ್ ಶೀಟ್. ಇದೆ ಚಾರ್ಟ್. Yes, page.
Page 164. Is the statement of the victim. I'll not trouble the court with the first volume. First volume, mate.
ಪ್ರಶ್ನಾವಳಿಗಳು.
Oh, sorry. Zero eight, 208. Page 208.
Ah, 208, yes. It's the victim state.
Yeah, this is the victim statement. I'm straight away taking the court because victim is the only witness to this incident and she is the victim. Para 2 at page 209 may kindly be seen.
Yes.
Later on, Sri Yediyurappa called me inside. At that time, my mother asked whether she too be permitted to come inside or not. At that time, he instructed my mother to be outside. Kindly mark this. So the guilty mind starts working. That is where it starts working. At that time, I thought that during inquiry of the previous POXO case, I have been inquired privately. So I thought like that only. So the girl thinks that it was for this reason. At that time, my mother also instructed me to give case details properly. Accordingly, I followed Mr. Yediyurappa. I went to one room which was situated beside the hall, in which few sofas and few tables were there. Immediately after entering the room, Sri Yediyurappa locked the door with the key. Kindly mark it. He locks the door, locking the girl inside the room. By observing this locking process, I thought why he is locking the door. He approached near me, asked, "Am I able to identify the culprits of previous case?" I say yes loudly. At that time, again, he asked about my age at the time of committal of the previous offense. I told 6.5 years old. Again, I repeated this word as he had not heard it properly. While repeating my age factor second time,
ಅದು ಓದೋದು ಬೇಡ.
ಓದೋದು ಬೇಡ.
ಯಾಕೆ? It's unreadable. Yeah.
That all the gory details are
Yes.
given out by the girl herself. Now this is what happened, and this is the offense reported to the police also by the mother, because the mother did not know what is happening inside, and the child comes out crying after she protests against what happened and directs him to open the lock. Pursuant to that, he opens the lock, lets out the child.
One thing, why you did not register the crime on that day itself?
Sorry,
On that day, 2/2/2023 is the
Yeah.
date of the incident.
incident.
Crime is registered on 14/3/20.
I
Why is
respect,
that?
I
That's all.
respect it. That also I will explain.
Ah.
I'll duly explain that. Now, now it is after that she comes out. The mother thinks after narrating because when she was 6.5 years old, the husband's relative rapes this child at home.
That is
That is
POXO
the
case.
first
POXO case.
POXO case, and it is to get justice in that case, she has approached the accused.
Yes, that is the narration.
Yes. So it is for that reason she had gone. And while seeking justice in that case, this is the treatment method. So thinking that the mother thought the child has become emotional because she recollected the gory details of her past. And therefore,
she was in tears. As they step out, the child holds the mother's hand and tells the mother, Amma, I have something to tell you. Then, very close by, there is a Starbucks coffee shop. They don't enter the coffee shop. On the footsteps of the coffee shop, mother and child sit, and the child narrates what happened to her in the room.
Immediately the mother rushes back
To the petitioner.
to the petitioner and confronts him. Now those details are given by the child. Para 4.
Yeah.
Para 4, page 211.
After crossing their gate.
After crossing their gate, my mother was little bit ahead. I was following my mother, called her Amma. She turned back, asked me what happened. At that time, I requested my mother to go to Starbucks coffee shop, existing adjoining to Yediyurappa's house. Accordingly, we went there.
By sitting outside of that coffee shop, I narrated the entire incident that has taken place inside the room of Yediyurappa's house. After hearing of the said incident, my mother got stunned. And again, we went back to Yediyurappa's house to confront about that incident. Then we went inside the gate of Sri Yediyurappa's house. Gunman man Aradhya, who sat near the main door, asked me what had happened. My mother replied again, we want to meet Yediyurappa. Then the gunman instructed us to wait for some time as Yediyurappa was meeting with some other persons. Meanwhile, my mother went inside within the compound itself and made a phone call to one lawyer by name R.R. Hiraman. Narrated the entire incident. At that time, I was standing near my mother. My mother told that the above said counsel has instructed us to talk calmly. Thereafter, my mother came to me, took out the cash from the bag which was given by Yediyurappa, and we took one selfie
with that cash. I forgot to mention this. Now, immediately after the girl protested in the room, the accused takes out cash and thrusts in the hands of the child. And after they come out, again he pays some more money
to the mother. Now, this is what she has narrated. So, when my mother was talking in phone, at that time, I was thinking that it is the previous case the police officials and public have asked me and my mother about evidence to prove the incident. Hence, at this time also, I thought that the officials may ask me about the evidence of the present incident. Then I made up my mind to record that the conversation to be held with the above said Yediyurappa. Then, without the knowledge of my mother, after taking up selfie with cash, the persons who were in the meeting came out.
Then while entering inside, I set my phone for recording. The persons who came outside, known by my mother, and my mother spoke with them and requested them to be there only till we come out. Accordingly, we entered the house. At that time, Yediyurappa was watching the TV. My mother asked him what he has done with her daughter inside that room.
Yes, sir.
My mother asked him what he has done with her daughter inside that room. Yediyurappa replied to my mother that I am just like his granddaughter.
Yes.
Immediately, my mother raised the question, if it is like so, why did you put your hand in her shirt or blouse? So I'll avoid that. But the fact of the matter is, the whole conversation was recorded by this girl
Where do I get that?
without the knowledge.
Where do I get that?
I'll place it immediately. Without the knowledge of her mother. And this is
The
important.
conversation inside the room or outside?
Sorry.
And the conversation that is recorded is inside the room at the first instance or when she came outside?
No, it is when they re-entered the house.
Re-entered.
Re-entered. First time she never suspected the bona
Suspect
fides of
to
the
record it.
petitioner. She never suspected. She thought he's only getting the details of the POCSO case. So it is in this backdrop. Now, what is very important to take note of is, now this conversation was recorded in a, which is that mobile? POCO mobile. POCO mobile. And the man who bought this mobile for her was her own brother, which fact has also come on record and it is established. Now thereafterwards, she uploads the video recording to her Google Drive, which is a documented.
That's what I see here.
Yeah.
In the statement.
To her Google Drive, she immediately uploads after the conversation was recorded. And
So in that recording of the conversation,
yes,
there is reference to what the petitioner did with the daughter inside.
direct reference.
That's all.
Kindly come to page 136. Straight away, I'll take the quote. Page 134, 21/3/2024,
Oh, ಇದು ಅವತ್ತು ಹೋದ್ರಲ್ಲ. Page 136.
page 135 is the request that this is the request made to the FSL seeking a report. Now kindly come to the statement actually.
Page 136 may kindly be perused.
Will not read out the names because the identity of the victim should not be disclosed. So she'll they enter. ಒಂದ್ ನಿಮಿಷ ಮೀಟ್ ಮಾಡ್ಬಿಡೋಣ, ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಒಂದೇ ನಿಮಿಷ ಹೋಗ್ ಬನ್ನಿ. ಸೊ ದಿಸ್ ಇಸ್ ವಾಟ್ ಆರಾಧ್ಯ ಟೆಲ್ ಸರ್. ಹೋಗ್ ಬನ್ನಿ, ಇಲ್ಲೇ ಇರಿ. ಅಪ್ಪಾಜಿ ಇಲ್ಲೇ ಇದ್ರ ಅಪ್ಪಾಜಿ, ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು ಒಳಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ? ದಿಸ್ ಇಸ್ ದಿ ಫಸ್ಟ್ ಕ್ವಶನ್.
ಒಳಗೆ ಕರ್ಕೊಂಡೋಗಿ ಏನ್ ಮಾಡಿದ್ರಿ ಅಪ್ಪಾಜಿ? ಸೆಕೆಂಡ್ ಕ್ವಶನ್. ಕೇಳು ಏನ್ ಮಾಡ್ದೆ ಅಂತ. ನನ್ ಮೊಮ್ಮಗಳ ಇದ್ದಂಗೆ ಅವಳು.
Yes,
ಸೊ ದಿ ಕಂಪ್ಲೇಂಟ್ ಸೇಸ್ ಒಳಗೆ ಬ್ಲೌಸ್ ಒಳಗೆ ಕೈ ಹಾಕಿದ್ರಂತಲ್ಲ ಅಪ್ಪಾಜಿ.
ಬೇಡ. Question and answer. So according to you, if that incident has not happened, why would she question in this manner is what you say?
Yeah, no, directly. And no, more important factor is he admits this fact.
Yes, check ಮಾಡಿದೆ.
ಹೌದು.
ಇಲ್ಲ ಮರಿ ಅಂತಾರೆ.
ಅದು ಕರೆಕ್ಟ್.
ಅಪ್ಪಾಜಿ ಎಲ್ಲಾರು ಹಿಂಗೇನಾ ದೌರ್ಜನ್ಯ ಮಾಡೋದು?
ಸೆಕೆಂಡ್ ಕ್ವಶನ್ ಇದೆ.
ಹಾ, ಎಲ್ಲಾರು ಹಿಂಗೇನಾ ದೌರ್ಜನ್ಯ ಮಾಡೋದು? ಸೊ ದಿ ಪೆಟಿಷನರ್ ರೆಸ್ಪಾನ್ಸ್, ನನ್ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ ತುಂಬಾ ಒಳ್ಳೆ ಹುಡುಗಿ, ಚೆಕ್ ಮಾಡದೆ ಅವಳಿಗೆ ಮುಂದಕ್ಕೆ ಒಳ್ಳೇದಾಗತ್ತೆ. ಸೊ he admits that he did it. ಅದೇನ್ ಬೇಕೋ ನಾನು ಸಹಾಯ ಮಾಡ್ತೀನಿ,
ಚೆನ್ನಾಗಿ ಅವಳನ್ನ ನೋಡ್ಕೊ
That I have seen.
ಅಷ್ಟೇ.
Yes.
ಹೀಗೆ ಸಹಾಯ ಮಾಡ್ತೀರಾ? 9 ವರ್ಷದಿಂದ ಹೋರಾಟ.
This is the recorded transcript on the mobile.
Sorry.
Recorded transcript of the conversation
Ah.
on the mobile.
And yeah, this is the recorded. And what is very important factor is
he appreciates the victim. Page 138, first sentence. Page 138,
ಎಸ್.
top of the page. ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳು, ಬಹಳ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು, ನಾನು ನೋಡ್ದೆ, ಚೆಕ್ ಮಾಡ್ದೆ, ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಸಹ ಯಾರೊಬ್ರಿಗೂ ಬಿಟ್ಕೊಡಲ್ಲ. ಚೆನ್ನಾಗಿ ಬೆಳೆಸು, ನಾನೇನೇನ್ ಬೇಕೋ ನಾನು ಮಾಡ್ತೀನಿ, ಇದನ್ನ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. So once again, appreciation because of the malafides and other things attributed, it becomes necessary to point out this last sentence in the same page. Kindly be perused. tells the mother, page 138. ನಿನ್ನ ನೋವು ಗೊತ್ತಾಗುತ್ತೆ, ಇಂಟೆಲಿಜೆಂಟ್ ಇದೆಯಾ, ಸೊ ಹಿ ಅಪ್ರಿಶಿಯೇಟ್ಸ್ ದಿ ಮದರ್. ಎ ಟು ಝಡ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದೀಯಾ, ಅವಳು ಒಳ್ಳೆ ಹುಡುಗಿ, ಬೆಳೆಸು, ಗೊತ್ತಾಯ್ತಾ, ಯಾವ ಕಾರಣಕ್ಕೂ ನಿನಗೆ ತೊಂದರೆ ಮಾಡಲ್ಲ, ಸರಿ ಮಾಡ್ಸೋಣ. ಸೊ ದೆನ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ rings up DK Shivkumar. I thought they're
ಎಲ್ಲ ಬಂದಿದೆ.
no, I thought they're politically at loggerheads till I read this conversation. Till I read this.
That's all right. All are friends, except on the field. Yes.
Then page 1 again he appreciates her. ಒಳ್ಳೆ ಹುಡುಗಿ, ಅವಳು ಒಳ್ಳೆ ಹುಡುಗಿ. Page bottom of the page. ಆಮೇಲೆ he compliments the complainant also. ಅದು ಡಿ ಕೆ ಶಿವಕುಮಾರ್ ತಗೊಳಪ್ಪ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಕಾಮೆಂಟ್ ಮೇ ಕೈಂಡ್ಲಿ ಬಿ ಪೆರುಸ್ಡ್.
Yes.
The complainant was appreciated by the petitioner. ಆದರೆ ನೀನು ಹಠವಾದಿ ಕಣಮ್ಮ, ಮೆಚ್ಚಬೇಕು ನಿನ್ನ. ಸರ್, ನೋ ಪೊಲಿಟಿಕಲ್ ಮೋಟಿವ್ಸ್ ಫಾರ್ ಅಟ್ರಿಬ್ಯೂಟೆಡ್.
No political motive.
ಇವಾಗ ಪೆಟಿಷನ್ ತುಂಬಾ ಅದು ಬರ್ದಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ
Petition ತುಂಬಾ. Petition ಬರ್ದಿರೋದು. ಈ ಕ್ವಶನ್
ಒಂದ್-
ಆನ್ಸರ್ ಯಾವ ಪೊಲಿಟಿಕಲ್ motive?
ಇಲ್ಲ ಇಲ್ಲ 139 ಬಾಟಮ್.
Again, victim, ಒಳ್ಳೆ ಹುಡುಗಿ. 140, I don't know why he makes this comment. He, petitioner says, his first answer to the question, ಕಲರ್ಫುಲ್ ಆಗಿ ಇರಬೇಕು, ಮತ್ತೆ ಒಳ್ಳೆ ಹುಡುಗಿ ಯಾವ್ದಕ್ಕೂ. I don't know why he made that statement. Anyway,
Anyway, it is the
Yeah.
conversation that is recorded,
yes,
transcript of that recording.
transcript is
Yes. Next. Based
Now,
upon,
then the petitioner collects the phone number of the complainant. Page 141.
Hmm.
She says her phone is lost. Somebody has stolen it. So ಅದಕ್ಕೆ ಮತ್ತೆ ನಿನ್ನ ಹತ್ರ ಯಾವ ನಂಬರ್ ಇದೆ ಮರಿ? ಅದೇ ಇವಳ ನಂಬರೇ ನನ್ನ ಇನ್ನೊಂದು ನಂಬರು ಕೊಡು, ಅದನ್ನ ಯಾವುದು ಕೊಡು. ಸೊ he demands and obtains the mobile number. So the mobile number is given. CW12, whose statement was read over by my learned friend Aradhya Anta. He is the man who collected the phone number, and it is he
who connects all the phone connections to the accused whenever a phone call is made. So his name has repeatedly come, and thereafterwards he collects the details that earlier also this lady had contacted him.
then he sends them to the police commission. Now, this fact that the recorded conversation, the transcript of which I have just now read, has been proved to the hilt. Number one, the sample of the accused was collected and sent for verification. And it matches with the voice sample of the accused. And that fact is borne out by the
the FSL report ಅಲ್ಲಿ
ಇದೆ.
page.
really come to page 570. 570. 570 to 579, volume 2. Come to page 572, bottom of the page.
Yes. are similar.
The words selected for substance analysis are mentioned below. ತುಂಬಾ
Yes.
ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು, ನೋಡ್ದೆ ನಾನು, ಚೆನ್ನಾಗಿ ಬೆಳೆಸು, ಬಹಳ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು, ನಾನು ಯಾರೊಬ್ರಿಗೂ ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳು, ನಾನು ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ, ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ. So this voice
Matches.
is compared. Yes.
It's similar is what is said.
Yes, the comparison of respective voices based on auditory and feature extraction methods have revealed the respective speeches said to be of male
So,
speaker.
of both the victim and the petitioner, it's confirmed.
Yes, confirmed. That is confirmed.
Yes.
So all the other details are also, technical details are also available in the following
Yes,
pages
that is there.
up to page 579.
Hmm.
Then, is this video marked? Is this video not a genuine one?
Hmm.
For this purpose, the video FSL report at page 592 may kindly, 582 may kindly be seen. 580.
Certificate.
Yeah. 582.
Yes.
Opinion at page 585.
Yes. I've seen.
Yes. So it is certified to be genuine and it is certified to be not marked.
Yes.
Then the mobile phone was sent to the National Forensic Science University of Gujarat
Adu report idea.
Ah.
Page.
for verification, page 550. Coming to the court, I saw there is a Forensic Science University.
ಪಕ್ಕದಲ್ಲಿದೆ.
Ah, I hope hereafter.
The IIM campus ಪಕ್ಕದಲ್ಲಿದೆ.
Yes,
IIT. Yes, next. National Forensic Science Laboratory branches here.
I think original this thing is at Gujarat.
Gujarat.
Gujarat. So the device that was sent, one mobile phone make Poco. Poco was the one used by the girl.
Yes, yes.
Model, etc. All the details are
These are
given.
reports there.
Now that was sent for verification, and the opinion is
Now the only issue is 161 statement ತಗೊಂಡು we should not entertain 480.
yes.
These are quite clinching, but the law, because so many judgments are given.
Yes. So
with-
I'm showing this and only one more, I'll trouble the court with only one more document,
Yes.
namely the petitioner was interrogated
Oh, where is
And
that?
this honorable court monitored it.
Where?
That is available. Kindly come to the
interrogation transcript. This is done after the court directed the interrogation to be done.
How many madam? ಎಲ್ಲ ಬರ್ಕೊಂತ ಇದ್ದೀರಿ.
ಬರ್ಕೊಂತೇನೆ. Only thing, the pages are not tallying with us.
But anyway, just check it.
Volume,
When you brief senior.
volume 2, 492 may kindly be seen.
492.
492.
ಪ್ರಶ್ನೆಗಳು. This is interrogating the petitioner.
Yes, petitioner's interrogation.
All right.
Question number 8 may kindly be perused. Complainant ನಿಮ್ಗೆ ಎಷ್ಟು ವರ್ಷಗಳಿಂದ ಪರಿಚಯ? 7-8 ವರ್ಷಗಳಿಂದ ಪರಿಚಯ ಇರ್ತಾರೆ. 493 ಎಷ್ಟು ಸಲ ಭೇಟಿಯಾಗಿರ್ತಾರೆ. He admits she has met him number of times. 14 may kindly be seen.
Yes.
ತನ್ನ ಮಗಳು ಪೋಕ್ಸೋ ಪ್ರಕರಣದಲ್ಲಿ ನೊಂದ ಸಾಕ್ಷಿಯಾಗಿದ್ದು ಯಾರ ವಿರುದ್ಧ SITಗೆ ನನ್ನ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ಕೊಡುವಂತೆ ಕೇಳುತ್ತಿದ್ದರು. His answer is ಮಹಂತ ಸಿಂಗ್ ಅವರು ತನಗಾದ ಅನ್ಯಾಯದ ಬಗ್ಗೆ SIT ಮಾಡಿ ತನಿಖೆ ಕೈಗೊಳ್ಳುವಂತೆ ಕೇಳಿರುತ್ತಾರೆ.
Yes.
15/2/24 ಕಂಪ್ಲೇನೆಂಟ್ ತನ್ನ ಮಗಳ ಜೊತೆ ನಿಮ್ಮ ಮನೆಗೆ ಬಂದಾಗ ಯಾವ ವಿಷಯದಲ್ಲಿ ವಿನಂತಿಸಿರುತ್ತಾರೆ? ಆನ್ಸರ್: ನನ್ನ ಮಗಳಿಗೆ ಸುಮಾರು 9 ವರ್ಷಗಳ ಹಿಂದೆ ಸಂಬಂಧಿಕನಿಂದ ಅತ್ಯಾಚಾರವಾದ ಬಗ್ಗೆ ಇದುವರೆಗೂ ನ್ಯಾಯ ದೊರೆತಿಲ್ಲ. ಟ್ರೇಡಿಂಗ್ನಲ್ಲಿ 4-5 ಸಾವಿರ ಕೋಟಿ ಮೋಸ ಆಗಿರುವ ಬಗ್ಗೆ ನ್ಯಾಯಗೊಳಿಸುವಂತೆ ಕೇಳಿದರು. ಕಂಪ್ಲೇನೆಂಟ್ ನೆಕ್ಸ್ಟ್. ಕಂಪ್ಲೇನೆಂಟ್ ಮಗಳಿಗೆ ಎಷ್ಟು ಹಣ ರೂಮಿನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ? ಹಣ ಕೊಡಲು ಕಾರಣ
ಹಾಲಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ. That's what he said.
ರೂಮಿನಲ್ಲಿ ಅಲ್ಲ, ಹಾಲ್ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ.
ಅದೇ.
ಅದು ತೊಂದರೆಯಲ್ಲಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿ ಕಣ್ಣೀರು ಹಾಕುತ್ತಾ ಇದ್ದುದರಿಂದ ಸಮಯದಲ್ಲಿ ಇದ್ದ 8-9 ಸಾವಿರ 9 ಸಾವಿರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಕ್ಸಾಕ್ಟ್ ಅಮೌಂಟ್ 9 ಸಾವಿರ ಹಣವನ್ನು ಕೊಟ್ಟಿರ್ತೇನೆ. ಸೊ ದಿಸ್ ಇಸ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ದಿ ಇನ್ಸಿಡೆಂಟ್.
Question number 18.
17th ಒಂದು ನಿಮಿಷ
17 ನೋಡೋಣ.
ಯಾಕೆಂದ್ರೆ
pictures.
ಪೊಲಿಟಿಕಲಿ ಮೋಟಿವೇಟೆಡ್ ಅಂತ.
ಸಹಾಯ ಆಗ್ಬಹುದೇನೋ.
ಆಡಳಿತ ಪಕ್ಷದ ರಾಜಕಾರಣಿ ಬಿಟ್ಟು ನಿಮ್ಮ ಹತ್ರ ಸಹಾಯ ಕೇಳಲು ಯಾಕೆ ಬಂದ್ರು? ನಾನು ಒಬ್ಬ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿ ಆಗಿದ್ದು ನನ್ನಿಂದ ಏನಾದರೂ ಸಹಾಯ ಆಗ್ಬಹುದು ಅಂತ ಬಂದಿದ್ದಾರೆ. 21 ಒಂದು ನಿಮಿಷ.
Yes.
ಕೈ ಹಿಡಿಯೋದ್ರ ಬಗ್ಗೆ
ಹ್ಮ್.
18.
ಅದೇ 18 ಹೇಳಿದೆ.
ಜೊತೆ ಅವರ ಮಗಳ ಕೈ ಹಿಡಿಯಲು ಕಾರಣವೇನು? ಮಗುವಿಗೆ ಆದ ಅನ್ಯಾಯದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲು ಆಕೆಯ ಕೈಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಮಾತನಾಡಿಸಿರುತ್ತೇನೆ. ನೋ ದಿಸ್ ಇಸ್ ದಿ ವರ್ಷನ್ ಆಫ್ ದಿ ವಿಕ್ಟಿಮ್ ದಟ್ ಹಿ ವಾಸ್ ಹೋಲ್ಡಿಂಗ್ ಹರ್ ಹ್ಯಾಂಡ್. 21/2/24 ಎರಡನೇ ಬಾರಿ ಬಂದಾಗ ನಿಮ್ಮನ್ನು ನನ್ನ ಮಗಳಿಗೆ ಏನ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಕೇಳಿದಾಗ ಏನು ಉತ್ತರ ಕೊಟ್ರಿ? ಯಾಕಮ್ಮ, ಏನಾಗಿದೆ, ನಾನೇನ್ ಮಾಡಿದೆ, ಹುಚ್ಚುಚ್ಚಾಗಿ ಏನೇನೋ ಮಾತಾಡಬೇಡ ಅಂತ ಹೇಳಿರುತ್ತೇನೆ. ದೆನ್ 23 ನಿಮ್ಮ ವಿರುದ್ಧ ಫೇಸ್ಬುಕ್ ಮತ್ತು ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ ವಿಡಿಯೋವನ್ನು ಬಿತ್ತರಿಸಿದ್ದು ನಿಮಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯಿತು? ಟಿವಿ ಮಾಧ್ಯಮಗಳಲ್ಲಿ ಬಂದ ಮೇಲೆ ತಿಳಿಯಿತು. ಆದರೆ ಅದ್ರ ಬಗ್ಗೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡಿರು. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ಇಟ್. He has not instituted any proceeding against her for 26 may kindly be perused.
Yes.
ಅರುಣ, ರುದ್ರೇಶ, ಮರಿಸ್ವಾಮಿ ಇವರುಗಳಿಗೆ ನೀವು ಏನೊಂದು ನಿರ್ದೇಶನ ನೀಡಿದ್ದೀರಿ? ನಾನು ಅವರಿಗೆ ಯಾವುದೇ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ನೀಡುವುದಿಲ್ಲ. ಅವರೇ ಸ್ವತಃ ಸೋರ್ ಅವರ ಮನೆಗೆ ಹೋಗಿ ಅವರೊಂದಿಗೆ ಮಾತನಾಡಿರ್ತಾರೆ. This relates to the subsequent offense.
Yes.
Where they brought back the mother and the victim and deleted all the evidence against them. 29 may kindly be seen. This happens on 20th when they bring these 3 people go and bring that lady and the daughter. So and so ಅವ್ರಿಗೆ 2 ಲಕ್ಷ ರೂಗಳನ್ನು ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ನೀಡಿರ್ತೀರಿ? ನೀವು ನೀಡಿದ ಹಣದ ಡಿನಾಮಿನೇಷನ್ ಏನಾಗಿತ್ತು? ಸೋ ಅಂಡ್ ಸೋ ತನಗಾದ ಅನ್ಯಾಯದಿಂದ ತನಗೆ ಬಾಡಿಗೆ ಮನೆ ಕಟ್ಟಲು, ಕರೆಂಟ್ ಬಿಲ್ ಕಟ್ಟಲು ಕಷ್ಟವಾಗುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿ ಕಣ್ಣೀರು ಹಾಕಿದ್ದರಿಂದ ಆ ದಿನ ನನ್ನ ಜೊತೆಗೆ ಇದ್ದ ರುದ್ರೇಶ್ ರವರಿಗೆ ನಿಮ್ಮ ಕಡೆಯಿಂದ ಏನಾದರೂ ಸಹಾಯ ಮಾಡಿ ಎಂದು ಹೇಳಿದೆ.
ರುದ್ರೇಶ್ 2 ಲಕ್ಷ ಹಣವನ್ನು ಆಕೆಗೆ ಸಾಲವಾಗಿ ಕೊಟ್ಟಿರ್ತಾರೆ.
ದಿಸ್ ಇಸ್ 214 ಡೈರೆಕ್ಟ್ಲಿ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್. 30 ನಿಮಗೆ ಭೇಟಿಯಾದಾಗ ಯಾವತ್ತಾದರೂ ಹಣದ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದಾರೆ? ಇಲ್ಲ. ಆದರೆ ರುದ್ರೇಶ್ಗೆ ದುಡ್ಡು ಬೇಕು ಅಂತ ಹಾಗಾಗಿ ಬೇಡಿಕೆ ಇಟ್ಟು ಮೆಸೇಜ್ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಗೊತ್ತಿಲ್ಲ. 31 ಕ್ರೂಷಿಯಲ್ ಕ್ವಶನ್ ಸರ್. ವಿಡಿಯೋದಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ ಬಗ್ಗೆ ಹೇಳಿರುತ್ತೀರಿ. ಏನನ್ನ ಚೆಕ್ ಮಾಡಿರುತ್ತೀರಿ? ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಕೈ ಹಿಡಿದುಕೊಂಡು ಏನಾಗಿದೆ ಎಂದು ಕೇಳಿದೆ. ಮಗು ಆ ಬಗ್ಗೆ ಏನೂ ಹೇಳಲಿಲ್ಲ. ತಾಯಿಯೇ ತನ್ನ ಮಗಳ ಪೋಕ್ಸೋ ಕೇಸಿನ ಬಗ್ಗೆ ತಿಳಿಸಿದರು. ಕೇಸಿನ ಬಗ್ಗೆ ಚೆಕ್ ಮಾಡಿದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತೇನೆ. ಸೊ that he has checked is an admitted fact.
What is a matter of evidence?
What is a matter is to be ascertained. 36.
Yes.
ಮತ್ತೆ 37 ಅಲ್ಲಿ he admits that he has paid 9,000 rupees. 40 ತೆಗೆದುಕೊಳ್ಳಿ ಒಂದು 40. ಅವರು ದೂರು ದಾಖಲಿಸಿದ ನಂತರ ನೀವು ಏನ್ ಮಾಡಿದ್ರಿ? ಯಾವುದೇ ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. 45. This Hiremat is the advocate
Yes.
to whom she immediately reports the incident, even before confronting the accused. Now that is an admitted fact that he doesn't deny that he is there.
So his defense is ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
Sorry,
His defense is ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
ಕೈ
Nothing
ಹಿಡ್ಕೊಂಡಿದ್ದೀನಿ.
else.
ಹಾ,
That's
ಚೆಕ್
his defense.
ಮಾಡಿದ್ದೀನಿ.
That's his defense.
ಚೆಕ್ ಮಾಡಿದ್ದೀನಿ. ಹಾ, ಅಲ್ಲ ಚೆಕ್
Check
ಕೈ
ಮಾಡಿ ಹೌದು.
ಕೈ ಹಿಡ್ಕೊಂಡಿರೋದು ನಾಟ್ ಎ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಫಾರ್ ವಾಟ್ he did later.
I'm only telling. That's his defense.
Then 46 may kindly be produced. ಏನೇನು ಮಾತಾಡಿದಿರಿ ನೀವು? ಹಾಲ್ನಲ್ಲಿ ಕುಳಿತು ಮಾತನಾಡಿರ್ತೇವೆ. ತನ್ನ ಮಗಳ ಮೇಲೆ ಸಂಬಂಧಿಕರು ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದಾರೆ, ಟ್ರೇಡಿಂಗ್ ನಲ್ಲಿ 5,000 ಮೋಸ ಆಗಿದೆ, ಈ ಬಗ್ಗೆ SIT ತನಿಖೆ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ರು. ಓಕೆ, 48 ತಾವು ನೋಡಿ.
Yes.
ನೋ ಮ್ಯಾಲಿಸ್ ಅನ್ನೋದಕ್ಕೆ ಇವರ ವಿರುದ್ಧ ಏಕೆ ದೂರು ನೀಡಿರುವುದಿಲ್ಲ? ಅಗತ್ಯ ಏನಿದೆ? ಆನ್ಸರ್, ಅಗತ್ಯ ಏನಿದೆ? ಆಕೆ ಈ ಮೊದಲೇ ನನ್ನ ಬಳಿ ಕ್ಷಮೆ ಕೇಳಿದ್ದರಿಂದ,
ಆಕೆಯು ಮಾನಸಿಕ ಅಸ್ವಸ್ಥರಂತೆ ಕಾಡುತ್ತಿದ್ದರಿಂದ ಅವರ ವಿರುದ್ಧ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ವಾಟ್ಸ್ 51. 2/2/24 ಡ್ರಾಯಿಂಗ್ ರೂಮಿನಲ್ಲಿ ಸೋ ಅಂಡ್ ಸೋ ಅವರ ಮಗಳಿಗೆ ಹಾಲು ಟೀಯನ್ನು ನೀಡಿದವರು ಯಾರು, ಅದೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ, ಯಾಕೆಂದ್ರೆ ಅದನ್ನ ಡಿನೈ ಮಾಡುವಂತ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಮೊನ್ನೆ. 53.
ಮಾಧ್ಯಮಗಳು ನಿಮ್ಮ ವಿರುದ್ಧ ಸುದ್ದಿಯನ್ನು ಪ್ರಸಾರ ಮಾಡಬಾರದೆಂದು ಆದೇಶ ಪಡೆದಿರುತ್ತೀರಿ, ಆದರೆ ಕಂಪ್ಲೇನೆಂಟ್ ವಿರುದ್ಧ ಈ ರೀತಿ ಆದೇಶ ಪಡೆದಿರುವುದಿಲ್ಲ, ನೆನಪಿರುವುದಿಲ್ಲ. ಇಟ್ ಇಸ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್. ಸೊ ಪಕ್ಕದಲ್ಲೇ ಕೂತಿದ್ರು, ಅದೆಲ್ಲ ಅಡ್ಮಿಟೆಡ್. 56 ಈಸ್ ಅನ್ ಅಡ್ಮಿಷನ್. 59 ಅಗೇನ್ ಕೈ ಹಿಡ್ಕೊಂಡಿದ್ದನ್ನ ಒಪ್ಕೊಳ್ತಾರೆ. 63 ಅದು ಇಟ್ ರಿಲೇಟ್ಸ್ ಟು ದಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇನ್ಸಿಡೆಂಟ್. 65 ಯಾಕೆಂದ್ರೆ ದಿ ಗರ್ಲ್ ವಿಕ್ಟಿಮ್ narrates about the details of the room to which she was taken, where she mentions about a curtain, sofas and table. He admits that. 65 ಕರ್ಟನ್ ಇದೆ, ಆದ್ರೆ ರೂಮಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
So these are the interrogating statements.
Yes.
Yes. ಈಗ 164 statement. ನೋಡಿ. I've seen the whole thing.
Yes. So this is the position. Now, why I say the petition is not maintainable? The copies in compilation. ಎದುರುಗಡೆ ಅವ್ರಿಗೆ ಒಂದು ಕೊಟ್ಟಿದ್ದೀರಿ. These are the compilations. I have given all the judgments relating, all the about POCSO proper. Kindly permit me to show. Only 3 of them I have relied. Starts at page 1. Attorney General versus Satish. It's a case where it shook the conscience of the
Yes.
nation, and even the Attorney General was forced to go to the court questioning what prompted the filing of this petition is a finding recorded at paragraph 5, page 19.
Yes.
Starts at page 19, come to page 20,
Yes.
subpara 30 may kindly be seen. So the act of pressing the breast can be a criminal force to a woman with the intention to outrage her majesty.
Yes.
Minimum punishment is so and so. 30. It is not possible to accept this submission for the aforesaid reason.
Yes.
Admittedly, it is not a case of the prosecution that the appellant removed her top and pressed her breast. As such, there is no direct or physical contact, that is skin to skin, with sexual intent without penetration. So he was exonerated of the charge. So this is commented upon, and the Honorable Supreme Court had occasion to examine in detail the entire POCSO Act and
Yes.
the analysis of the POCSO Act may be perused
Yes.
at para 24 onwards. The detailed analysis of section 7 is found at page 31.
Mm. Yes.
So there, I'll not trouble the court with the details. We don't have that problem. There, there was no allegation that he had inserted the hand in the blouse.
No, here there is.
So that now para 33 sets out the act, the object of the act, and para 34 is important. Kindly permit me to read it. Now, from the bare reading of section 7 of the act, which pertains to the sexual assault, it appears it is in two parts. The first part of the section mentions about the act of touching the specific sexual parts of the body with sexual intent. The second part mentions about any other act done with sexual intent which involves physical contact without penetration. Since the bone of contention is raised by the learned senior advocate so and so, with regard to the words touch and physical contact used in the said section, it would be beneficial to refer to it. Now, I'll not trouble the court with that because we don't have that problem in this case.
Yes.
The finding of the court on this aspect may kindly be gathered at page 29 bottom. Placitum H may kindly be perused. The very object of enacting the POCSO Act
Yes.
is to protect the children from sexual abuse. And if such a narrow interpretation is accepted, it would lead to very detrimental situation, frustrating the very object of the act, inasmuch as, in that case, touching the sexual or non-sexual parts of the body of a child with gloves, condoms, sheets, or with cloth, though done with sexual intent, would not amount to an offense. The most important ingredient of constituting the offense of sexual assault under section 7 of the act is the sexual intent and not the skin to skin contact of the child. Then presumption under 2930 referred to in para 39.
Yes.
Para 39. It may also be pertinent to note, having regard to the seriousness of these offenses under the POCSO Act, the legislature has incorporated certain statutory presumptions. Sections 29 permits the special court to presume when a person is prosecuted for committing or abetting or attempting to commit any offense under section 3, 5, 7, and 9 of the Act, that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. Similarly, section 30 thereof permits the special court to presume for any offense under the Act which requires a culpable mental state on the part of the accused, the existence of such mental state. Of course, the accused can take a defense and prove the fact that he had no such mental state with respect to an act charged as an offense in that prosecution. It may further be noted that though, as per subsection 2 of section 30, the purposes of the said section, a fact is said to be proved only when the special court believes it to exist beyond reasonable doubt, and not merely when its existence is established by preponderance of probability. The explanation to section 30 clarifies culpable mental state includes intention, motive, knowledge of a fact, and the belief in or reason to believe a fact, thus on the conjoint reading of 7, 11, 29 and 30, there remains no shadow of doubt that though as per the explanation to section 11, sexual intent would be a question of fact, the special court, when it believes the existence of a fact beyond reasonable doubt, can raise a presumption under section 30 as regards the existence of culpable mental state. The next paragraph, placitum E may kindly be seen. The court cannot be oblivious to the fact that the impact of traumatic sexual assault committed on children of tender age would impact of could endure during their whole life and may also have an adverse effect on their mental state. The suffering of the victims in certain cases may be immeasurable. Therefore, considering the objects of the POCSO Act, its provisions, more particularly pertaining to sexual assault, sexual harassment, etc., have to be construed vis-a-vis the other provisions so as to make the object of the Act more meaningful and effective. Then conclusion, para 45 may kindly be, 44, 45 and 46 may kindly be permitted to be read. In the light of the aforesaid discussion, legal position, the findings recorded by the High Court are appreciated. Clearly emerges that the High Court fell into error in case of the accused Satish in holding him guilty for the minor offense of 342 and 354 and acquitting him of the offense under section 80 of the POCSO Act. The High Court, while specifically etc., 45, item B may kindly be approved. So far as section 7 of the POCSO Act is concerned, the first part thereof exhausts a class of act of sexual assault using specific words, and other part uses the general act beyond the class denoted by the specific words. In other words, whoever with sexual intent touches vagina, penis, anus, breast of the child or makes the child to touch so and so, so and so, so and so would be committing an offense of sexual.
Read everything, marked everything.
Yes.
Next judgment.
So this is what
In
the
compilation,
Attorney General case
in compilation, ಮುಗಿಸ್ಬಿಟ್ಟಾರೆ.
referred to the court. Justice Ravindra Bhatt ಅವ್ರದ್ದು ಜಡ್ಮೆಂಟ್ ಇದೆ ಕೇಸ್
Manoj versus Soames.
ಬಹಳ ಅದು ಚೆನ್ನಾಗಿದೆ.
Yes.
ಅದು
That's elaborate
much more emphatic.
Yes,
Then
importance of forensic.
yes, kindly come to page 47.
Hmm.
Delay court was pleased to ask me
POCSO.
how do ಇದರಲ್ಲಿ 6 months delay. 6 months delay and
POCSO cases, sometimes it is, there is a delay of 1 year also which is taken note of.
yes,
And it is said.
yes.
The judgment in Gurmeet Singh's case takes care of it.
And the para 7.
Direct judgment, ಅಂದ್ರೆ you're talking of Rajiv Kaurav.
ಹೌದು.
That's what I referred on the other day.
Aye.
I myself followed and held. 161 statement ಮೇಲೆ para 8 and 10 of Rajiv Kaurav, if you see.
ಇದೆ ತೋರಿಸ್ತೀನಿ ಅದನ್ನು ತೋರಿಸ್ತೀನಿ.
Para 8 and 10 of that judgment,
ಹೌದು.
which says the High Court had relied on 161 statements and quashed the proceedings under 482.
ಮಾಡಕ್
At
ಬರೋದು.
para 10, Supreme Court says that relying on 161 statement and quashing the proceedings under 482 is not available.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಮೋರ್ ಎಂಫ್ಯಾಟಿಕ್ ಗ್ರೌಂಡ್ ಇದೆ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ-
ಮಚ್ ಮೋರ್ ಎಂಫ್ಯಾಟಿಕ್. ಇದ್ರಲ್ಲಿ ತಾವು ಒಂದ್ ನಿಮಿಷ ತಾವು
ಯಾವ್ದು?
ಪ್ಯಾರಾ 11, 12 and 13 ಪರ್ಮಿಷನ್
Page ಇದ್ರಲ್ಲ.
ಪೇಜ್ 50 ಇದೆ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ.
ಹಾ.
In our considered opinion, observations made in para 9 of the impugned order are totally unwarranted, have been made overlooking the specific allegations contained in the FIR, duly supported with the statement of the victim girl child under section 164. This is very important. Importance of this. Then 12. Sir, this applies both to the anticipatory bail application that has been filed, which is also, yeah, ತಮ್ಮ ಮುಂದೆ ಇದೆ.
ಅದು ಇದೆಯಾ?
ಹೌದೌದು, ಅದ್ರ ಮುಂದೆ ಇದೆ. It directly applies to that. So here itself I will point out, para 12. In a case containing such serious allegations, High Court ought not to have exercised its jurisdiction in granting
Granting
protection
protection against.
against arrest. As the investigation, without saying that appearance before the investigating officer, who has been prevented from subjecting respondent 1 to custodial interrogation, can hardly be fruitful to find out the prima facie substance in the allegations
ಈಗ
which are
ಚಾರ್ಜ್ ಶೀಟ್
affecting.
ಆಗೋಗಿದೆಯಾ?
ಇದರಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ಆದ್ರೂನು ಕಸ್ಟೋಡಿಯಲ್ ಇಂಟ್ರಾಗೇಷನ್ ಮೇ
ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ
it would have been much more fruitful. That's all what I'm
ಇವಾಗ
saying.
when it was
Yes, it would have been much more
when
fruitful.
the
You would have
coordinate
been
when
more
the coordinate bench
Yes.
interdicted.
ಯಾಕೆಂತಂದ್ರೆ ನಾನು ಇಂಟ್ರಾಗೇಷನ್ ವಾಟ್ ಐ ಡಿಡ್ ನಾಟ್ ಶೋ ಇಸ್ ಮಾತು ಹೇಳಿದ್ರೆ ಅವರು ಇಲ್ಲ ದುಡ್ಡು ಕೇಳಿದ್ರು ಅದನ್ನ ನಾವು ಪ್ರಶ್ನೆನೇ ಕೇಳಿಲ್ಲ ಅವರು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು. ಆದ್ರೂ ಪ್ಯಾರಾ 13 may kindly be put. So it would have been much more. So can hardly be fruitful to find out the prima facie substance in the allegations which are of extreme serious nature. The fact that the victim girl is traumatized to such a high degree that her academic pursuits have been adversely impacted alone, coupled with the legislative intent, especially reflected through Section 29 of the Act, are sufficient to dissuade a court from exercising discretionary jurisdiction in granting pre-arrest bail. It
Yes.
may be true, as pointed out by the learned counsel appearing for respondents. Charge sheet has already been filed. So here also, charge sheet has already been filed. It will be unfair to presume on our part that the investigating officer does not require respondent 1 for custodial interrogation for the purpose of further interrogation. So this case it applies. Kindly come to para 16, very serious nature. So I'll not trouble the court with the rest of it.
Yes,
They are general in
I will.
nature. Now next case, sir, that is a very important case. Just rights for children.
Yes, that is Justice
There is an exhaustive
Chief Justice.
review
Yes, yes.
of case law. It is
ಇದರಲ್ಲಿ settlement ಮಾಡಬಾರ್ದು, all that is said.
Justice Pardiwala's judgment.
Yes.
It was relating to pornographic this thing, and the High Court had quashed the proceedings.
That is Madras
against
High
that.
Court.
Yes. Now the entire POCSO law is reviewed
Yes.
from
yes.
page 66, para 39.
Yes.
Page 66 may kindly be perused.
Yes.
There is a detailed,
No, that
Narration.
runs up to 165.
yes,
Is that-
160, yes,
Lengthy order.
very, very lengthy order, very detailed
Yes,
consideration,
that is importance of POCSO.
importance of POCSO. 51 is especially important,
Yes.
presumption is
Yes.
highlighted. 53, the case law is reviewed from
Yes.
53 onwards. I'll not trouble the court with the case law.
Yes.
There is a very important section in this paragraph, in this section, which relates to the aspect of the final finding may kindly be perused. IT Act is reviewed there afterwards. T6. Kindly come to the presumption part of it. Sections 29 and 30 are dealt with.
Para 185
Page
to 190.
154,
Para 185.
well, I'll come to 185. Page 154, it starts.
Finally at
Yes, yes,
para
yes,
190
yes,
and 194.
yeah, one. I'm obliged for that observation. What is statutory presumption? What is its impact? It has been examined in detail. 185, I'll read 185, page 128. From the exposition of law, it is clear. There is no bar for the High Court to invoke statutory. The reason why this came. Now, section 29 uses the special court shall presume. So it is only for the special court for that presumption,
Scope is expanded here.
not under 482. So this was the argument. So therefore, the court had this to
That's
say.
good. Scope is
There is
expanded.
no bar for the High Court to invoke the statutory presumption at the stage of deciding quashing petition
in respect of any offense to which such a presumption is applicable. Rather, any failure to give due weightage to the same may result in dire consequences such as premature quashing of the criminal proceeding or allowing an accused to completely bypass the statutory presumption, which otherwise would have been applicable at the trial. In the light of our earlier discussion, and without again referring to the plethora of decisions, it is clear how the statutory presumption plays a vital role when it comes to offences such as those under the POCSO. This court in Attorney General held that considering the objects of POCSO, its provisions, etc., any selective reference to a particular provision in complete ignorance of the other provision would result in mutilation of the entire scheme and purport of the legislation and thereby defeat the purpose for which it was enacted. The High Court, as a matter of choice, kindly mark this,
Yes.
the High Court, as a matter of choice, should not shy away from referring to the statutory presumption that has been incorporated in the Act whilst deciding a quashing petition. The High Courts must not deal with a particular offence under any enactment devoid or in disregard of the rest of the statutory framework. It must recognize and refer to the legislation in total. Otherwise, it would give an undue advantage to an accused by allowing him to mischievously prefer a quashing petition before the trial commences, completely bypass the statutory presumption provided by the legislature, walk right away from the criminal proceedings, thereby setting the entire legislation at naught. It is imperative for the courts to discourage any such attempts on part of the accused to short circuit the statutory provisions and procedure laid in a particular act and evade trial entirely. In such situations, the statutory presumption becomes all the more important to effectively ensure that such criminal process is not manipulated in any devious accused. In Prakash Nath Khanna and Ratish Babu Unikrishnan, any defense of the accused for the purpose of rebutting said statutory presumption should ordinarily be left to the trial court to be looked into, at least when it comes to quashing petitions. Though in certain exceptional cases, High Court may do so and so, so and so, so
No, that
and
is
so.
always there.
Bogus, it is there. But in doing so, the High Court must be slow and circumspect, must exercise some restraint. The statutory presumption may be ignored only where no foundational facts have been established from the material on record. Once the foundational facts are prima facie established from the material on record, it would be improper for the High Court in a quashing petition to conduct an intricate evidentiary value into the facts and ascertain whether the requisite mental elements are present or not. All these aspects should be left to be decided by the trial court, which is the appropriate forum.
Yes.
190. When the High Court quashes any criminal proceeding without considering the legal effect of the statutory presumption, it effectively scuttles the process of trial, thereby denies the parties the opportunity to adduce appropriate evidence and the right to a fair trial. This would not not only defeat the very case of the prosecution, but would also thwart the very object of particular legislation and thereby undermine the public confidence.
Yes. We'll go to the next one.
Yeah. So this is what.
On POCSO ಆಯ್ತು.
Yeah.
Now this is Rajiv Kaurav, page 165,
Yes, 160.
para 6.
Yes.
Last 5 lines of para 6, para 8 and para 10.
Yes. I've also placed authorities by this honorable court.
Yes, Niranjan Hegde's case.
Yes,
I
where
myself
once
read.
the charge sheet is filed, the accused should be relegated to.
No, that is D. Ravishankar, Justice Dikshit ಅವ್ರದ್ದು.
So, ತಮ್ದು ಇದೆ judgment.
ನಂದು ಇದೆ ಇಲ್ಲಿ.
Yeah.
That is at
ನಂದು ಇದೆ.
page 199.
Yes, yes. So,
That was a case of dowry death.
Rajiv Kauradu,
Rajiv Kaurav, yes, straight away. That is
161 statement,
that is what it
direct
said,
authority,
direct on the.
direct authority.
ಅದು ನಾನೇ ಹೇಳಿದ್ದು ಇವತ್ತು.
ಹೌದು.
16 ರಾಜೀವ್ ಕೌರವ್
True.
ಇದೆ.
ಅವ್ರು ಮಾಡ್ಬೋದು ಅಂತ there is a direct authority
para 10 is sufficient.
Yes. And in Iqbal's case, Supreme Court said, Justice Pardiwala said, once charge sheet is filed, remedy is discharged.
So,
Exceptional cases, this court can interfere. Then you're relying on Justice Dikshit or the case
Okay.
of where this page 476,
472.
right to telling power of cost so and so.
Sidramaia's case itself
Sidramaia's
is an
case,
authority. It was relied upon.
Yes. So there again,
Then cognizance on which my learned friend has very elaborately argued. I have given any number of judgments.
yes,
That is in volume 2,
yes.
first section.
So there are two ways.
Sole
where-
testimony of the victim can be the basis for conviction, not only for,
So at least there should be trial is what you say.
yes, therefore, that is given in section, second section of volume 2.
Yes,
I
yes,
given number of cases.
yes, yes.
Delay, it has no application to
Gurmeet Singh ಕೊಟ್ಟಿದ್ದೀರಾ?
case of sexual offences, that also I have given. Malafides, I have also shown there are no malafides.
There is one judgment.
And one factor, court may kindly consider this.
Yes, sir.
Now 14.3 FIR is lodged. 19.3 he goes to court, obtains an ex parte injunction against 73 defendants
Hmm.
who are all media houses.
Oh,
Not a whisper of political motive, not a whisper of any malafides. And more importantly, the complainant is not made a party to that OS.
in that way.
Yes, I have placed that plain copy also in the matter.
Now, with all this, according to you, the delay will not inure to the benefit of the petitioner for quashment. These are matters of trial and it's case of POCSO, where this court should hold its hands in quashing the petition when there is prima facie evidence.
And raise a presumption,
Prism, that-
29 and 30, direct presumption that
that's
he is guilty. And I have shown how a guilty mind has operated at every step, interrogation,
Because question on
confrontation.
the mobile recording is.
Mobile recording clinches the issue, if I may say so with respect.
That's. all
One
right.
last thing before I conclude. This is a gross abuse of the process of the court for the simple reason. Sir, kindly note one important date. The petitioner was keeping silent without raising his voice, without protesting against what she had done, without even proceeding against her till her death. She died on 26/5/2024. In all probability, the petition to file was ready, but they had their own apprehension. Now kindly come back to the writ
When was
petition,
it- when was it-
memorandum of writ petition for a minute.
Was it filed?
At 12/6 it was filed.
After the death.
Waiting for the death. Why I say so, kindly look at the affidavit.
The petition?
Yeah. The memorandum of writ petition, original petition may kindly be. Sir, it is dated 12/6/2000. Petition is dated 12/6/2024.
Hmm.
And it is sworn to by an affidavit which was 1 week earlier, 1 month, 1 week earlier, 5/5/2024.
So it was not kept ready to be filed.
Sir, what I am saying is, this is not a petition verified by that affidavit. This petition should be thrown out lock, stock and barrel on this simple ground. There is no verification. Because this refers to the developments in June, when notice was issued, annexures E and F for his appearance. That was in June. So it is a calculated effort on the part of the petitioner to move the court immediately after the death of the complainant.
We'll consider.
And having said all this, I request the court to kindly take note. Incident occurred on 2/2. We are almost 17 days away, just 17
For a
days
year.
away from 2/2, which is the mandatory requirement under the act.
Before that, you will get the order.
Yes.
Yes,
Big-
17th,
Yes.
sir is coming on 17th, right?
Civil suit to page 161 alliದೆ.
Charge sheet ಅಲ್ಲಿ ಇದೆಯಾ?
ಅಡಿಷನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ.
ಕುಡಿಯೋದು. ಹೆಚ್ಚುವರಿ ದೋಷ.
Sir, we have tried our best to present our case. Nearly 20 dates list ಆದ್ರೂ we did not get an opportunity to present.
ಇವತ್ತಾಗಿದೆಯೋ ಇಲ್ವೋ?
ಇವತ್ತಾಯ್ತು. ಇವತ್ತಾದ್ರಿಂದ ಇವತ್ತು ನಾನು ಏನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೋತಿದ್ದೀನಿ ಅಂದ್ರೆ ಇವತ್ತಿಂದ ಡಿಸ್ಕಂಟಿನ್ಯೂ ಹಿಸ್ ನಾನ್ ಅಪಿಯರೆನ್ಸ್.
See, I have heard and I will hear him on 17th.
4 ದಿವಸ ಅವ್ರನ್ನ ಹಿಯರ್ ಮಾಡಿದಿರಿ.
ಅಲ್ಲ ಮತ್ತೆ ಇವತ್ತು only 1 hour on that day,
Please.
not more than that. We'll finish it before 2/2/2025.
ಅಲ್ಲ
Definitely.
ಟ್ರಯಲ್ ಮುಗಿಬೇಕು. ನಿಮ್ proceeding ಅಲ್ಲ.
We'll see. We'll pass our order.
And
Before that date.
what shocked me, my conscience, I'll share it. Earlier I had said it. My learned friend put a question to himself saying that because of delay, I am trying to meet the delay on that the interim order was made without hearing the prosecution. No, the interim order was made after hearing the learned advocate general. I was not on record. And I ascertained this from him. Sir, 55 years I have been a student of law. 50 years I am a lawyer. 45 years I have taught law. It is unheard of. I believe the learned advocate general confirmed this to me. Therefore, with all responsibility and humility at my command, I make this submission. It appears the judge asked before passing the interim protection, is he a Tom, Dick and Harry? So this jurisprudence is unknown. Tom, Dick and Harry jurisprudence is unknown to law. I am extremely saddened by that kind of an observation, which is the basis for the interim order.
Previous bench.
ತಾವು ಅದನ್ನ ಹೇಳಿದ್ರಿ,
ಹೇಳಿದೆ.
ಕಂಟಿನ್ಯೂಷನ್ ತಾವು ಹಿಂದಿನವ್ರು ಮಾಡಿದ್ದು ಅಂತ ಹೇಳಿದ್ರಿ,
ಹೌದು.
ಬಟ್ ಕಂಟಿನ್ಯೂಷನ್ ಇಸ್ ಈಕ್ವಲ್.
I have never said those statements. According to me, however high they are, the law is above them.
That
That's
is
all.
precisely. Be you ever
That's
so
all.
high,
It
the
can't,
law is above you is the well-known adage.
according to me, that is the thing. Yes.
204 to 2 ಇದ್ರ ಬಗ್ಗೆ
204 to?
he also made a submission that cognizance under 204 and 214.
No, for offenses under section 214,
Yes.
204 and 214.
Yeah.
That is against the others in the companion petition,
You.
not against
accused one ಅಲ್ಲ.
Yediyurappa.
Ah.
Not against Yediyurappa. Others we will see.
ಅದನ್ನ ಹೇಳ್ತೀನಿ ಬೇಕಂದ್ರೆ ಅವ್ರು ಮುಗಿಸ್ಲಿ.
ಅದ ಮುಗಿಸ್ಲಿ. ಅದ್ರಲ್ಲೇನು ಅವರಿಬ್ಬರದ್ದು ಪೆಟಿಷನ್ ಅಷ್ಟೇ ಅದು 204 to 214.
ಅದರ ಸಪರೇಟ್ ಎವಿಡೆನ್ಸ್ ಇದೆ, ಅದನ್ನು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
All right.
ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಅನ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್. ಹಿ ಸೇಸ್ 2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ ನಿಜ ಅಂತ, ಸಾಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾರಿಗಾರು ಕೊಟ್ರ ಅಂತ ಕೇಳಿದ್ರೆ ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ, ಇದೇ ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು. ಅಂಡ್ ಹೋಲ್ ಥಿಂಗ್ ಆಫ್ಟರ್ ದಿ uploading of the complaint, she complains to the President of India, to the Union Home Minister, to the Police Commissioner, to the DGP, everything on record. And in this age of digital this thing, she uploads immediately after the confrontation on 2/2 itself. Where is the question of delay in this? Please.
But the earlier order for granting, you said Tom Dick, it's the way of putting it. No fault can be found with.
Great respect, such observation should not come from the mouth of a constitutional court. With all humility, I
way of-
submit, because that gives a wrong signal. I don't know whether the court had,
The Lordship is so erudite that sometimes.
I have no doubt about it. But
Believe-
that was the saddening part, that it came from his mouth.
Sometimes
I-
it happens.
Yeah.
Was the most erudite judge of this court. 17th. Ata online bandra sir.
Please.
Yes.
My lords
Heard
have
the
said-
learned senior counsel, Professor Ravi Verma Kumar, who completes his submission in writ petition 15522 to hear learned senior counsel C.V. Nagesh list the matter on 17th. Only 1 hour.
ಆಂಟಿಸಿಪೇಟರಿ ಬ್ಯಾಲ್ ಬಗ್ಗೆ
ಹಾ.
ಜಸ್ಟಿಸ್ ಫಣೀಂದ್ರ ಅವ್ರದ್ದು ಒಂದು ಜಡ್ಮೆಂಟ್ ಇದೆ.
ಅಲ್ಲ.
ಡೈರೆಕ್ಟ್ ಆಗಿ ಬರಂಗೆ ಇಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿ.
ಹಾ,
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ.
ಆಗಿದ್ರೂನು ದಟ್ ಇಸ್ ವೈ ಐ
So that judgment is will
Delayed.
consider.
custodial interrogation,
Custodial interrogation would be required.
maybe, I don't know.
That's what.
Right.
Charge sheet
Please.
ಆದ್ಮೇಲೆ we'll consider it. Yes.
My lords,
Please.
may I request it at 2:30, ma'am?
2:30 ಆಗ್ಬೋದಾ?
Please.
2:30, even if it is 7 o'clock, you should finish
Please,
that
my
day.
lords. My lords, the interim order.
That will continue.
Please.
Please,
Yes.
oblige.
Grateful.
Come back to. ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಆ ಲಿಸ್ಟ್. Back to the main list. ಧಾರವಾಡ list.